Welcome to Score Business TV. In this series, experts share their opinion with business owners on a variety of topics. Today's topic is a continuation of the one we began in our last episode, the 10-step business sales process. We previously covered steps 1 through 5. Today, we'll conclude with steps 6 through 10. Each step will be explored with experts in a free-flowing dialogue. But before we begin, I'm happy to introduce two experts in the field. First, we have Peter Gruitz. Peter has had a distinguished career as a banker, realtor, and a business owner. He leads our exit strategy team. Peter is also a SCORE mentor. SCORE is a 55-year-old nationwide nonprofit organization providing free mentoring services to business owners. And we're also happy to welcome Matthew Lapointe, principal at Blaylock Walters, PA, a Sarasota and Bradenton, Florida law firm. Matthew is a principal in the firm's business, corporate, and healthcare law practice groups. Matthew represents companies in all business sectors. Welcome, gentlemen. Today we're continuing our discussion of the 10-step business selling process with steps 6 through 10. But before we do that, let's quickly list the first 5 steps. Step 1 was arrange for a professional or intermediary to represent you. Step 2 is conduct an in-depth review of the business, including financials, leases, contracts, assets, and liabilities. Step 3, obtain a business valuation. And step 4, prepare a business prospectus. Step 5 was develop a marketing strategy. So now moving on, let's address step 6, list the business for sale. Peter, let's start with you. Where should a seller list their business for sale?
Well, if they're going to do it on their own, they can go to Biz Buy Sell and buy a listing for 3 months. If they are going to hire a broker, then the broker is going to accommodate that listing arrangement.
A lot of times, brokers will put ads sort of in trade magazines and things like that. Of course, you don't want the ad to disclose the name of the company, but to give enough flavor of the company that buyers will have enough to at least make that second step, take that inquiry. There are other people who are probably very likely buyers that a good broker would reach out to, like competitors in the industry, or sometimes a supplier or vendor, up above or below the chain of that particular company in that industry. Those are often good prospects as purchasers. Reaching out to CPAs and business lawyers like myself is often a good idea. CPAs and business lawyers often know of companies that are on an acquisition mode and are looking for companies. So all of those outlets are good places to look, and a good business broker or investment banker will also have their own list of people who they know are sort of in the market or looking for investments and stuff like that. So it's really quite a few options.
Yeah. I want to follow up on the confidentiality aspect that you mentioned briefly. So why is that important?
Well, you certainly don't want your advertising of your business for sale to be so easily recognizable that people in your company know that the company is for sale. It's often, it is not, in only very rare cases would you want your staff and employees to know that you're selling the company. It's best not to do that, not to make that known until quite far along in the process. Now, it may be necessary to tell your CFO, for example, and your top salesperson, perhaps, but you certainly don't want it to be common knowledge.
And Peter, let me ask you about commissions for a moment. What might a seller expect to pay in commissions for the transaction?
Well, all commissions are negotiable, and there is no fixed commission. Many people think there is a fixed commission, and because this guy charges that, that's what the standard is. But they're all negotiable. But in general, for a business that's under $1 million, or the transaction's under $1 million, it's not untypical to see a 10% commission charge.
Okay. Step 7, meet with prospective buyers and qualify them. Matt, let's start with you. Why is that important?
Sure. Well, it's important to know who your buyers are for a lot of reasons. One, you want to make sure it's not just somebody out kicking the tires. You don't want to waste your time with somebody who doesn't have the ability to buy, or isn't really serious. Second, a lot of times, particularly in the smaller deals, the seller will take some paper, will hold some paper, will make part of the loan to the buyer in order to acquire the business. And if the seller is holding a note from that buyer, you obviously want to make sure that the buyer is going to be able to pay that note and has the financial wherewithal to handle the note. So those are the two main reasons.
Few things are as exciting as getting an offer for something. If you get an offer, you're excited because you put all this work into this, and now someone actually recognizes that what you're offering is worth buying. So there's a great tendency to kind of shortcut everything because of that offer, and not to really recognize what is required of that person who's making the offer. It's very easy to forget in the excitement of it all that you're really getting someone to apply for a job to work your business. And so you really need to ask questions about really what are their effective availability of cash? How are you going to pay for this? Do you have some evidence to point to me where I can see whether or not you're qualified? What have you done that would qualify you to take over this business? And how is your experience going to make this business grow? Those are fundamental questions that have to be asked either by your broker or by the seller, and that's part of the qualifying process. You get 2 or 3 people people will actually walk into stores and say, I want to buy your business. And well, okay, and then you tell them everything about your business. You haven't signed a non-disclosure agreement. You haven't gone through putting anything in writing, and all of a sudden you're negotiating against yourself. So that really is a very important thing to know, that qualifying that buyer and having a methodology to qualify that buyer with an attorney looking over what's dealing with your broker, in effect making sure that they have asked those kind of qualifying questions. We won't show a house if we're going to do real estate unless we know that's a qualified buyer. Why would you let somebody see all the inside of your business unless you know they're a qualified buyer?
I came across an interesting comment that I read on the internet, and it was from a very valid source, but I'll leave that out. According to business brokers, 9 out of 10 respondents to for sale ads aren't qualified to make a purchase. So a lot of your time is going to be wasted unless you can figure out how to qualify them. Matt, should you do a background check to vet the buyer?
Yeah, I would say it depends on the industry, but that's certainly not a bad idea. If your industry is any kind of regulated industry, for example, if it's a restaurant and you have a liquor license, someone with a felony on their record cannot have a liquor license. So it's a disqualifier right there. So depending upon the type of business, yes, a background check might be a good idea.
In a transaction like this, time is of the essence. Many people forget that. And to close a business deal is going to take a minimum of 90 days, and sometimes could take a year. And if you are fooling around with somebody who doesn't know what they're doing, or expect you to, in effect, finance the whole transaction because they don't have to put any money down, and you see a lot of that on the internet today, your time's being wasted, and you're locking up your property, you're locking up your business, and wasting your time for an extended period of time, and you're taking yourself off the market. So you cannot just nonchalantly accept people to talk to you about the sale of your business. You have got to be very specific, and don't even, I would say, don't even talk to them until you have a non-disclosure agreement in place. And then any offer you're going to get, insist that it's in writing. It isn't worth anything if it's not in writing.
Matt, when should you meet with a prospective buyer, and where should you meet with them?
Well, before I answer that, I do want to echo Peter's comment about the non-disclosure. That's very important. Before you share any information, Peter's right. Before you share any information with that buyer, you need to have a good non-disclosure agreement. And no offense, but please don't just take one off the internet and change the names around. Please talk to a lawyer about the non-disclosure and get one that's tailored to your business. I mean, sometimes you want to add in there that the buyer's not allowed to speak to your vendors, or that they're not allowed to speak to your employees. That should be in every one. There's also sometimes a buyer will want a lockup, like Peter was just talking about, an agreement on the part of the seller that they won't continue to try to find other buyers, that they'll negotiate with this buyer exclusively. Those kinds of things need to be covered right up front in that very early non-disclosure document.
Is that referred to as a no-shop clause, or am I thinking?
Yes,
Okay.
no,
Right.
a no-shop clause. That's what it's called.
Okay, so getting back to my question on when should you meet with the prospective buyer and where should you meet with them?
So when you should meet with them is after you've qualified them, the way Peter's just described, after they've signed a non-disclosure confidentiality agreement. And the meeting should probably take place not at your business, not at your office, anywhere else. Have it at your CPA's office, at your lawyer's office, your business broker's office. But I wouldn't recommend having it at your business, because we talked earlier about the need to keep the fact that the business is for sale quiet. Bringing someone into the office who's not someone anyone's seen before, who is looking around and stuff, it just is very easy to tip off. People do learn before you want them to learn. It's amazing. They always, somehow, the employees figure out that the business is for sale. But you don't have to help them by bringing the potential buyer right into the company.
Ideally, you want to have a bidding war, but that's easier said than done. So Peter, let's start with you. How can you get a bidding war going where you have several people expressing an interest in buying your business?
A good listing, a good executive summary, something that in effect points out where this business is going to go and why, getting back to what Matt talked about earlier, you've got to target who your buyer is going to be. So you have to have an idea of who you're going to sell this to and why you would sell it to them. Now, that's one of the things that the SCORE exit team really excels at, is trying to focus every one of these sellers to really what are they going to say yes and no to. You have to know before you walk into a meeting what you're going to say yes and no to. You have to do some mathematics before you go in through the process, because there's an attempt to, in effect, work on you when you're in that meeting. And you would also have to find out what the experience of this buyer is. This buyer could be just a tire kicker who's going to waste your time, is going to take up all kinds of real estate in your mind, and is not going to do anything. And so you really need to find out if they've done this before. How many business deals have they bought before? Have they ever bought a business deal before? And why is this business appealing to them? In other words, you have got to find out what their triggers are to buying the business if you're going to have a meeting.
Okay. Step number 8, negotiate and accept an offer. Matt, let's start with you on that one.
Sure. Well, this is where the rubber meets the road. This is it. The buyer obviously wants to get the best deal that he can get. The seller wants to get the most money that she can get, and so it's a matter of negotiation. Who has the power in the negotiation? Well, that depends upon how badly the buyer wants your business, whether you've got that bidding war that you talked about a few minutes ago. If you do, then the seller's really in the catbird seat. They can really dictate terms, so to speak, and can compare and contrast the two offers from the buyers and pick the one that's better for them. But that negotiation, I would say the business owner really needs to do a lot of listening and needs to rely on their experts, the broker and the CPA primarily, on the financial aspects of the thing. And the lawyer at this stage, not so much. In the negotiation, it is usually mostly financial, although there can be some legal issues as well. Deal structure varies significantly. Sometimes a buyer will want the seller to stay on in an employment capacity or in an independent contractor capacity for a period of time. Well, will that be compensated or uncompensated? At what rate would that be compensated? Sometimes the buyer wants the seller out of that business immediately. That's fine too. But those are the sorts of things that need to be negotiated.
Peter,
That first meeting is not a deal. That first meeting is an opportunity for you to qualify the buyer. That's an opportunity for you to say, I like you, I'm interested in you, and I'll have to get back to you on this, because you don't want to make a decision on the first time that you meet them. You have to do some investigation. So your qualifying process is that first meeting or second or third meeting that you're having to, in effect, start to bring together all the elements of the deal. Because a good deal is a good deal. A bad deal, you don't want to enter. You want to walk away from a deal that's going to hurt you if you see it out there.
Yeah.
let's talk about the components of cash and accounts receivable. So obviously the cash in the business is yours, and the accounts receivable is negotiable. What would be some advantages and disadvantages of retaining the accounts receivable or having the buyer collect it and maybe pay you a percentage or so?
Sure. As you say, it can be done either way. We're talking primarily here, we're talking about an asset sale. And so in an asset sale, the company, the LLC or the corporation, sells what it owns, which is all the equipment and the customer lists and whatever value it has, and that can include accounts receivable. So the question is, when is it good to sell accounts receivable? When is it good to keep it? I'd say buyers will not purchase accounts receivable on a dollar for dollar basis. They will always want to discount the price that they're going to pay for the accounts receivable. So if you have $100,000 in AR, they will perhaps offer 80% or 75% of that. Why do they do that? For one thing, they don't know the collectability of these accounts. They don't know whether these accounts are, strong or weak. You can sort of tell when I'm representing a buyer. We ask for an aging of the accounts receivable. We want to know how much of that is net 30, how much is net 90, how much is 120. Anything over 90, we discount pretty heavily.
Eliminate it.
Yeah, right. Or just figure you're not going to get it.
That's right.
So that's the sort of a little bit of a negotiation that happens there. If you're going to sell the accounts receivable, is at what discount are you going to sell it? Now, you may decide not to sell it at all and to keep it. A factor there is, will you have the wherewithal to collect it? I mean, most companies have somebody, or in big companies, they have a staff whose responsibility it is to collect the accounts receivable, to send out the reminder notices and stuff like that. So once you sell your company, you no longer have that person or that staff, and so you're going to have to do it yourself. Is that something you want to bother with or be bothered with, or is that something you want to do? Or is it better to just take the 80% of it and go home? So it's a matter of judging those factors and deciding what makes the most sense for you.
Matt, let me ask you this question. Can you define what an earnout is and how that interplays into a transaction?
Sure. An earnout is, I would call it sort of a contingent part of the purchase price, where the seller agrees. Let me rephrase. What the buyer is trying to get at with an earnout is confirmation that the customers that it's paying for, the goodwill that it's paying for, actually materializes after the deal. And so an earnout is an incentive to the seller to do what's necessary to make sure that those customers remain with the company and that goodwill is passed along. So a lot of times it's done in a way that the seller might stay on as an independent contractor or as an employee of the new buyer to ensure the transition of those customers. And there are often certain milestones that have to be met, certain numbers that have to be met for the seller to get that extra money on the sale price.
Okay. Peter, let me ask you about installment sales. Okay, as far as an installment sales go, is that something that frequently happens? And if you could just weigh in on the benefits, perhaps, of doing that, maybe from a tax standpoint, although you're not a CPA.
Well, an earn-out and a provision to take paper is what you're really asking. And if you express that in an installment sale, or you present value the numbers as you go along, is an opportunity for a seller to get a greater benefit of interest, for example, that a bank would get if the bank was going to finance the whole deal. So it's very important that the seller have a strong level of confidence in reference to that business can produce that by that installment loan, and that there are not impediments to him getting paid. Now, some installment notes can run as much as 5 or 10 years. It really depends on the nature of the business and the credit worthiness of the buyer.
So at this point, we've agreed on our terms and we've negotiated a deal. Is the letter of intent ready to rock and roll?
Yes, I would say letter of intent would happen after you've got the outline of your deal. The basic business structure is set, and oftentimes the broker will draft the letter of intent. Again, not to harp on this too much, but I would recommend you have the lawyer take a look at that letter of intent before it's signed, because there are some things that should be covered that aren't always covered. But yeah, the letter of intent would be the next step. And then after that, the actual drafting of the purchase and sale agreement.
Okay. And when does due diligence come into play? Peter, why don't you start with that one?
Well, it comes after you have a deal.
That's right.
So after you've had a deal, you're now put all the terms together. Now you're going to, in fact, check out what elements of the deal are really valid and what are the flaws in the deal. Also, the letter of intent is not something that you just accept because somebody wrote a letter of intent. Your advisors, your attorney, your accountant, your SCORE mentors have got to look at that letter of intent and see if it really captures your point of view in reference to the spirit of the deal, whether it's a good deal or not. A letter of intent sometimes will have all the times will have some element of good faith money. But that good faith money is not like a deposit on a house. If you don't come through on the house, I get to keep the money. On a letter of intent, that usually is not the case.
Okay. Let's move to step 9. Step 9, have your attorney draft the appropriate documents. What documents might they be, other than the ones we just mentioned?
Sure. So after the letter of intent, you get to what we call the definitive agreement. It's usually, in the case of a smaller business, an asset sale, an asset purchase and sale agreement. So that's the primary document. Oftentimes, attached as exhibits to that document are other documents that are going to be signed at the closing. If I could just analogize it to a house. When you go to buy a house, you sign a purchase and sale agreement. That's not the actual purchase of the house. That's the promise to buy the house 30 days from now, or whatever it is. At the closing, the seller delivers to you a deed. That deed is what physically and legally transfers ownership of that house. Okay, so in the business context, the asset purchase agreement is the purchase and sale agreement. At the closing, however, there are a number of documents, including the equivalent of the deed, which is called a bill of sale, but there are other documents that need to be delivered at the time of closing. So a lot of lawyers will prepare the asset purchase agreement and then put as exhibits to the asset purchase agreement those documents that will be expected to be signed at the closing, so that both parties know exactly what those documents are going to be that are signed at closing. Long way of answering your question. Now, what are those other documents? Well, I've already talked about the bill of sale. There's also often a non-competition agreement. And if I'm a buyer, I'm insisting that there's a non-competition agreement, because I want to make sure that that seller doesn't sell me the business and then go and start a new one, 5 miles away, compete with me. Another important document, Dennis, is the promissory note. If the seller is going to be loaning some of the purchase money to the buyer, a promissory note documents that. Now, the promissory note should also be secured by something. Oftentimes, we'll use a security agreement in an asset sale. That is usually a second position on the part of the seller because a bank has financed the primary amount of the purchase price, and often we'll ask for a personal guarantee from the buyer as well to guarantee that note. Those are your basic documents.
Okay, let's go to step 10. Step 10 is close the transaction. Peter, they say every deal dies 1,000 deaths. So how do we help things go smoothly? What can a seller do?
Well, I think you have to plan every element of this. You need to get good, experienced advice as you go along. And then you have to be careful that you pay attention to all of the details. Every detail in the deal can come back and bite you. And if you miss one element of it, it could be something that you face for 2 or 3 years in the future. So once again, don't sign anything unless you really know what you're signing. Don't sign anything unless you really have thought it through and you, in effect, have planned all of that.
Matt, what can go wrong with the deal at the end?
Well,
especially talk about leases and landlords.
Sure. So Peter's absolutely right. It's the details. And, I always make myself a checklist of all the items that I need to make sure are covered before we get to that closing table. One of the big ones, as you're intimating, is the lease, the situation where the business is located. Well ahead of time, well ahead of the closing. Do not wait until the day before the closing. The buyer needs to start talking to that landlord about either an assignment of the lease from the current owner to the new owner or a new lease to take over once the new buyer gets in. That's one of the things that will often throw off a closing is if they haven't gotten a relationship with the landlord set up. Another thing that throws off the closing is if you don't have your financing lined up. This is very frustrating sometimes. The banks usually will give the buyer a long list of all the items that they need, and if you don't get them everything on that list, they will not give you the money. They will not close the deal.
Matthew and Peter, thank you so much for being our guests today on Score Business TV. You've touched on a lot of important information on a subject that is of vital importance if you're selling your business. I'd also like to thank our viewers and our sponsor, Wells Fargo. Please tune in next time for our show on how to buy a business. This is Dennis Zink for Score Business TV.